I want to start with an overview of the firm of Braun and Gresham, and Cassie mentioned that we're here to give the landowner perspective in that very often the conservation easement transaction is just one part of the service we're providing to our clients. An important component of the work, and it's often correlated into many of their other needs, not only estate tax planning, income tax planning, but we're also working with them on potentially lobbying, litigation, water rights, oil and gas, property tax matters. So just a general overview into the type of practice we have. And our firm is very focused on estate planning for legacy land. Almost all of our clients that we'll work with will have some piece of property which is especially important to them. It may have been in their family for many generations. It may be just a land legacy that was articulated to them by their parents and grandparents, that they feel a very strong relationship to their property, and they're interested in trying to do some type of protection or monetizing of environmental values for their property. And so we believe very strongly that the landowner's goals should guide the planning process, that we're focused on understanding their needs, their situation, and then helping those goals guide where we're headed with the representation. So here's an estate planning definition from our firm. Proper estate planning allows us to protect our property, provide for ourselves and our loved ones without giving up control of our affairs, plan for the possibility of our own disability, give what we own to who we want, the way we want them to receive it, and when we want them to receive it, and then lastly, to save every tax dollar, professional fee, and court costs that are legally possible to save. 5 major challenges that we face in this work. The first is asset protection, disability protection, the decision to probate or not to probate, minimizing federal estate tax, and leaving a legacy. And I want to emphasize here with a graphic the way that we're looking at this. We find that many professionals start out the discussion and the analysis trying to use the tax code provisions in a way to try and minimize the estate tax bill, to save as much tax dollars as possible. But we believe that many times if a lawyer will sit down and listen to their client, they'll find that that's not actually their top priority. They may choose to leave a legacy and to protect their property, even if it means paying a little bit more in estate taxes. And so we're encouraging everyone to plan with the right priorities, starting with understanding the needs of the family, the needs of the individual, protecting the wealth, expanding the wealth, and lastly, to save taxes. And we have found that for many people, that is their preference, that they would prefer to protect their property, and maybe it doesn't involve minimizing the taxes to the greatest extent possible. And we'll tell you some success stories at the end of the presentation to illustrate this a little bit farther. So first step, challenge number 1, our asset protection. It's very important when you start doing estate planning or disability planning that you have a really comprehensive overview of the assets that are owned by the individual and how those assets are held, because the title to the asset will control what happens to the property if there's a lawsuit, if the client becomes disabled, or when the client dies. And what I mean by that, I want you to think in terms of not only property, how the property is owned, but also other assets like bank accounts. Many clients may not appreciate that the way they have titled that bank account, as an example, if they're holding it joint tenants with right of survivorship, that's going to dictate what happens to those assets when they die, not what the will says. So very important that everyone understands that. We'll often see property owned outright, but in married situations, the couples may have the property owned where one interest is passing freely from one spouse, or where the interest, the right of survivorship, will kick in and the surviving spouse will own the asset outright. And then many properties, whether it's real property or other assets, may be held in an entity. This title issue, again, as I said, it's going to be important either for disability scenarios, death, or creditors, bankruptcy. All of these issues come into play. And so let's review the planning options. There are really three. The first is no plan. Nothing has been done. What happens when the client becomes disabled? If they have a debt they cannot pay, or upon death? There will be a distribution plan that'll be dictated by the way the law works. The assets may be attached and they may be sold if there's a debt. Or, of course, the property will pass according to the rules of intestacy, which is the backup plan that state law provides, how the assets are passed on through the family if you don't have an estate plan in place. Using risk management techniques can be an important mechanism for planning for protecting the assets. And planning the estate will enable the landowner to dictate how these assets are going to be passed on. And all of this is geared toward focusing on how these assets will pass on to the next generation. As I said, who will get it, how will they get it, when will they get it? Now, there are many mechanisms that are in place under Texas law that landowners should avail themselves of to help protect their assets, even before any type of scenario like this, a disability or a death. So I want to run through them very quickly. We recommend that every landowner assess their property in terms of the homestead. There's homestead protections under Texas law that are provided by the tax code related to minimizing your property taxes for your homestead, but also protecting you from creditors. We say creditors and predators. And under the law in Texas, a married couple is entitled to protect 200 acres of property in a rural area. If they live in a rural area, they can claim that protection. It's a very strong protection against creditors, but it is recommended that you file a homestead affidavit to declare that. The first step is speaking in terms of using an entity for non-homestead land, and the reason why that's important to consider is because a business entity can't claim the homestead. So anytime a landowner is evaluating what homestead do they want to declare, how much of the homestead, do I want to put this property in entity, they have to evaluate this back and forth. Statutory protections. It's important for you all to know that Texas, like many states, provides some statutory protections designed to encourage people to have recreational use on their lands. We have a recreational use statute. If you comply with the statutory provisions, which are primarily focused on if you're charging for your property and what level of insurance you are carrying, then you can lower your level of care that's owed to your guests, and it provides some statutory caps on damages. So these statutes require some affirmative actions by the landowners. You want to make sure you qualify, but the protections are strong, and they're something you should avail yourself of. Similarly, we have an equine statute in Texas. If you have a client or a landowner who is having a lot of horse operations on their property, they should familiarize themselves with the equine statutes and the requirements there, which will avail themselves of additional protections. We always recommend that landowners have comprehensive waivers. Requirements for waivers change over time based on developments in the case law, but waivers are an important mechanism to inform your guests about what risks are involved in coming out on natural property, to make sure they make an informed decision, because you don't want anyone hurt on the property, and to protect the landowner in those cases. And then thorough leases. It's amazing how many people have lease arrangements that are not documented on the back of a napkin. Whether you're looking at people having leases for hunting, oil and gas, or use of structures on their property, maybe they have a land manager out on the property, you want to have those leases thoroughly documented, make sure that all the critical terms are addressed in writing. We're recommending inspection protocols for landowners because those dangers that are out implicit in nature are something that you want to be warning your guests about if it's something that they're likely to come across. And a lot of times landowners are not really looking at their property from the eye of their guests. So a periodic and a regular inspection schedule can be very beneficial for identifying any latent dangers on the property. Man-made dangers are especially of concern because there are heightened requirements for protection of those. So as an example, a wobbly deer lease is something that you'd want to be staying on top of and making sure your guests are not out using man-made structures which are not in good working order and could present some risk to the landowner. And signage is always a good recommendation, signage related to any unusual risks and signage related to private property and posting your property. Safety instructions go along with this. If you have people coming out and are using equipment like ATVs, canoes, especially any motorized equipment, you want to make sure that they are being informed about the manufacturer's recommendations for safety and that they're complying with those recommendations. You would never want to have a landowner have people come out and not follow the manufacturer's recommendations for safety and then have somebody injured on the property. And as I mentioned earlier, the insurance amounts that they're carrying are very important for making sure they're adequately insured and qualifying for statutory protections. The last recommendation there is emergency protocols. This is probably unusual for attorneys, but we do like to offer our landowners who are doing some risk management assessments an opportunity to have us do some checking in advance to find out if you had somebody bit by a poisonous snake or stung by a wasp and have an allergic reaction. Do you know what facilities are in your area? Who are the quickest to respond? Who are adequately stocked to deal with those types of emergencies? Because the difference of a few minutes can make the difference in whether somebody saves a limb or not. So you want to have those numbers handy, and we will do that research for landowners and have those contacts in place. And I want to circle back to the top one because I think the use of an entity is the most critical. And our topic today on estate and disability planning, don't want to get too off topic, but I do want to stress that there are so many benefits to landowners who consider putting their property into a business entity, both because it enables them to separate that asset and any torts or liabilities that may arise from that asset from their other assets, their home in town, their car, their other interests. You have the opportunity to shield the personal assets from the ranch assets. The real property will often be the source of most of the risk that a family faces. So if you can separate those two, there's a lot of benefit to that. It also enables you to do more of a common management amongst the family, to get the next generation involved in decisions that are being made about the property, to become more familiar with the decisions that have to be made, the expenses. And so it's a way to start passing on and coordinating management and even pass on shares of that business interest to the next generation without having a very fragmented ownership, because every owner on the title exposes that asset to risk between the creditors of all of those individuals. It's a way to protect the property and preserve the legacy. Our second challenge is disability planning, and it's a common theme that the title will control, because if someone becomes disabled and they have not done any disability planning, they will go to, there will be a process through the probate court similar to not having a will, where a guardian will be appointed for them. And so the planning options are as follows. Doing nothing, the no plan requires the guardianship, which is appointed by the court for the assets and for the person to make decisions on the well-being of that person. It's possible that guardian could even be a creditor. It's not necessarily going to be the person that the individual would pick. So it's much more preferable to use powers of attorney, both medical powers of attorney and financial powers of attorney, so that that person can pick the individuals that best know them, that are familiar with their needs and their desires, and articulate these things to that person in writing and to their doctor. And then the use of the revocable trust is another step that is a very good mechanism in disability planning. It enables you to put your assets in a trust. You're the trustee. You can choose to add or remove those assets at any time, how you control them. But if you do become disabled, then the trust is going to continue right on, and the substitute trustee will be familiar with your rights and your goals for those assets. So when you're working with a landowner, so many landowners will think they have a will and that they've finished with their planning, but please remember that the disability planning can be very critical for many families. Thomas is going to jump in and walk you through the next 3 challenges.
Thank you, Allison. Since there's so many folks from the land trust community here today, I want to make sure that I speak directly to your experience. Has any of the land trusts that are here today had a situation arise where their landowner has become disabled? No one. Okay. Well, be on the lookout for that situation, right? Because as population ages and this grantor who donated this wonderful conservation easement gets older, the likelihood of disability increases, and especially with the advent of medical technology. So you might encounter a situation where you're not dealing with that landowner anymore. You're dealing with an agent appointed under a power of attorney, or you're dealing with a creditor who was appointed as a guardian of the estate. We have planned in the easements what happens when a transfer of the property occurs, right? The land trust in some cases gets notified. Usually I've seen provisions in easements that do that, but we generally don't plan for what happens if the landowner becomes disabled. Well, usually if the property is transferred, there's a title run and the new buyer is alerted to the fact that that easement is on the property. But at disability, that doesn't occur. There's no title run. It could be a distant relative from, Boston who suddenly is in control of this ranch with an easement on it. That person might have no knowledge of the easement. So you can see why this is important to you and to your landowning clients. There has to, when we talk about a disability plan, this is what we're talking about. We're not just talking about, well, does he have a power of attorney? What is the land trust plan in that scenario? Have you had that discussion with your landowner? Do you know who that agent is? You see the issues, why this is important? We're broadening the discussion. We're giving the land trust community some additional conversation pieces to have with their clients, their landowners, that will benefit not only the landowner, but will benefit and provide clarity to the land trust so that they know, hey, Mabel isn't doing too well. Suddenly there's a new face when you visit that land. Somebody else is opening the gate. You don't know that person, but they're there because Mabel is disabled. Okay? So that's why we think that this is an important topic to raise in this regard. Now I'm going to talk about probate. Allison has mentioned probate. If a person doesn't have any sort of disability planning with powers of attorney or trust in place and they become disabled, maybe Alzheimer's, maybe they're in a coma from an accident, you have to go to a probate court in whatever county the land is located or the person is located in order to establish the guardian for the estate. It's a similar thing when someone dies, okay? So I just want to briefly run through this process about what happens. It could be the case that the person doesn't have a will, and some landowners, as you know, don't have those instruments in place. Many of them do. So whether you have a will or you don't have a will, you're going to run through the probate process. Has any of the land trusts here today had a situation arise where the landowner has died and the property goes through probate? Wow, I'm kind of surprised at that. I guess we're dealing with a lot of first-generation grantors, okay? As the landowning population ages, you're going to have this. I don't think you need to worry about this necessarily, but again, it's another issue to have on your radar screen because you could be dealing with an executor under a will. And maybe that's a family member who knows about the easement, but it could be someone who has no knowledge of the easement. Well, what if they start making decisions that run contrary to the easement. You can see the potential for violation is great in both of these situations where disability strikes and where death occurs. So you need to be prepared. You need to understand what the lay of the land is in that situation. So we'll talk about this probate process briefly. Let's say you have a will. The will has to be admitted into the probate court, usually the person that's named as the independent executor. That's the most common thing in Texas. Petitions the court, applies to the court to be appointed as the executor. There's a brief hearing. The person is issued letters testamentary. Then they can deal with all of the decedent's assets. They marshal all those assets together. They gather them together. They do an inventory of those assets. Those assets have to be, that inventory has to be put into the public record in the court file in most cases. They need to publish a notice for all of the creditors of the decedent to come forward and present claims, and the executor has to determine whether those claims are legitimate or not, pay the legitimate claims, deny the illegitimate claims, and then distribute the rest, the residuary, to the decedent's heirs. Well, in that residuary is the land with the easement on it, okay? And that's where you need to pay attention, because who these heirs are might have no knowledge of the easement. They could be distant relatives. Suddenly they're in possession of this property. Again, this is not a traditional sale where someone has handled a title commitment and a copy of the easement. This is a situation where people find themselves owning a property under easement, have no knowledge of the easement, and could start making decisions because they believe that the property is unencumbered with the easement. So again, I'm surprised no one has had this experience, but pay attention. If one of your landowners dies, you need to at least be aware of that situation and involved in the process to the extent that the land on which you hold this interest is running through this process. Okay? So that's the job of the independent administrator. At the end, the property is titled and whoever the heirs are, and suddenly you've got a new landowner that you have to develop a relationship with. So in Texas, there's just a few options to deal with the probate process. Some people, of course, don't do any sort of planning. That's as much a plan as doing a will. Because if you don't have a plan that you've created yourself, the state of Texas has one for you, and it's the state intestacy statutes, which will determine who takes that property if you haven't specified that in your will or living trust. So, again, this could give rise to completely unexpected heirs. Someone that, the landowner never believed would take this property. Could be an estranged son who has a legitimate ownership interest under the laws of intestacy, but has no knowledge of the property. Could suddenly come into possession of the property. And this is the situation where the most conflict arises. Anytime that there's land and there's heirs that come out of the woodwork to find what the decedent owned, if they have an interest that's due to them, for example, under the intestacy statute, this could give rise to conflict among the heirs, and the land trust at least, again, needs to be aware of the situation here. So if you use a will, if you write out what your wishes are, it can be a handwritten will. And I've seen some of those. I just am dealing with a client right now. Beautiful penmanship, I don't think I'll find that maybe in the younger generation. I know my kids have terrible handwriting. But luckily she had beautiful handwriting. I don't think there'll be a problem probating a handwritten will. Most wills, of course, are drafted by attorneys. Regardless, it has to be admitted to probate. It doesn't avoid probate because there's a will. It guarantees probate. So you're going to be in that process if the person has a will. Really, the only way to avoid probate, and for some people this is an important issue, and largely I find with landowner clients, it's driven by their desire for privacy. They own this land, a long way from the city on purpose. They want to be left alone in many cases. They're not interested in having other people, their neighbors, know their business, right? So they want that privacy. They don't want to have that, the asset inventory disclosed. So what are their options? Well, they can create, if they still want to control the asset and live on the ranch and continue to operate it, then they can create a trust, a revocable or a living trust, not an irrevocable trust, but a revocable trust, a trust that they can change the terms of or completely revoke at any time. So they're the trust maker, they're the trustee, they're also the beneficiary. They own all the hats, they wear all the hats, they control the property completely. So a trust is like my briefcase, okay? It's a receptacle into which the trustee, the trust maker, can place assets. And in this case, maybe they're deeding their ranch under the easement into the trust. So if you have a provision in your easement that has some trigger for the land trust to be notified, sometimes it's a $100 fee I've seen, it might be triggered in the event of that kind of transfer, even though we're not transferring between a new grantor. It's not a third-party sale. They're just making a kind of interfamily transfer. I have seen land trusts and landowners get into squabbles over terms that were poorly drafted, that maybe there's a reserved right that's personal to the owner, right? So it's personal to Joe, but Joe creates a living trust that he's the trustee of, and he transfers that asset in. Well, does he still have that right? Well, that's a question, okay? That might give rise to some creative decision-making and mediation between the land trust and the landowner. So the trust, when you place those assets into the trust while you're alive, you no longer own it. The individual no longer owns it. So therefore, when they die, there's nothing to probate. They've essentially pre-probated their estate by placing the asset into the trust while they're alive, okay? So at their death, the process of administration is very easy and clean. It doesn't go through the probate process. There is no published inventory. There's really no public record. And for many landowning clients, this is an important consideration. But even if you create elaborate trusts or have elaborate provisions under your will, if the property is titled in such a way that it avoids probate, then it's not going to enter into the probate process. It won't be governed by the terms of the trust in that case. It'll pass directly outside of probate. That's very hard to do with real estate in Texas. Texas doesn't really permit joint tenants with right of survivorship. I hardly ever come across that for land. It has it for bank accounts and such, but rarely does it have it for land. What I have seen in a lot of rural counties, veterans organizations will distribute these community property survivorship agreements at the Veterans Hall, and people retitling their property under these types of agreement that pass the property directly to the surviving spouse at the death of the first spouse as a probate avoidance mechanism. Again, that's just something to be aware of in your relationships with the landowner. Okay, so we already talked about using the funded revocable trust and the importance of coordinating assets with whatever estate plan you create. Just skip on. These are the documents that are in a traditional estate plan. This is the kind of foundation, the basic estate plan. I'm not talking about advanced kinds of planning here. We'll get to that in a minute. It's just important for you to have an understanding of what these types of basic estate plan looks like. It's either going to be a will or a living trust. If the trust is funded, there's going to be a deed for the ranch, placing it into the trust. There's financial powers of attorney to handle the disability planning issues. In trusts, there are also, and this is an interesting factor, trusts are generally more sophisticated techniques for dealing with disability than powers of attorney, because powers of attorney they don't have to be honored by third parties, and sometimes they're not. So if the land is owned in the trust, then I've often seen a test for disability that's written into the trust. In other words, when does the landowner become disabled? Well, usually it's one medical doctor, but maybe the landowner wants to set a higher bar than that. So they say 2 medical doctors, or maybe it's 1 doc and the well spouse, okay? So trust can have that kind of provision in it. It can name the successor trustee, the disability trustee who steps in, and it can provide, most importantly, from your perspective as land trust, a set of instructions to deal with the assets in the trust to care for the person who is disabled. And that set of instructions might include notification to that disability trustee that there's an easement on the property. Okay? So you can see where there's a crossover there that could be important in a disability plan for a trustee. I'll just mention a couple of the other issues here that might be of interest. Location lists. Usually we provide some sort of map that clients can create for themselves to leave a trail of where their important documents are located, so that someone, maybe it's the niece from Boston who flies in because grandma has passed away or is disabled, so that someone can find where those documents are. Well, a copy of the easement's in the public record, of course, but maybe a copy of the easement, should be given to the landowner specifically for this purpose to keep with their important estate planning documents. So consider that when you're talking with your landowners on that issue. Now we're going to talk about federal estate tax. And this is a conversation that has been evolving specifically over the last 10 or 12 years as the laws have constantly changed. Well, now, at the end of 2012, at the 13th hour, Congress finally acted to make these estate planning changes permanent. So I want to finally be able to say something with some authority that's not going to change next year. But who knows what permanent means in the congressional dictionary. So what is the federal estate tax? Well, it's a tax on your right to transfer property at death. Now that's taken out of the tax code, and that's a great definition that the federal government created. Who would have known that you had to pay a tax at that point? Well, you might not have to, and so we'll talk about it. How do you calculate it? It's very simple. Add up everything you own or have an interest in. This could include the ranch, that could be very, very valuable, but it could include a life insurance policy that the decedent owned, okay, so the decedent controlled it, but the decedent nor the beneficiary or the decedent has no, the decedent is dead. He doesn't have a benefit of that policy. It goes to somebody else. So let's say single landowner names the kids as the heirs to his estate, but he wants to make sure they're also provided for, so he takes out an insurance policy on his life, names them the beneficiaries. That person passes away. That insurance policy is included in his estate for estate planning purposes. This could push the policy beyond the threshold to create a federal estate tax liability. So even in an estate where you look around and you see, well, they don't own very much, they've got a ranch, it's not very valuable. If they've got this big insurance policy, even though the landowner is not going to benefit from it, somebody else is, that could push their estate over the threshold and create a federal estate tax liability. Why is that important? Because it could have implications for the exercise of reserved rights under your conservation easement. Maybe there's a right to partition, and now these people are forced to have to exercise that right because they need something to sell to pay the federal government. The tax rate has been changed from 35% last year. Actually, this slide is incorrect. It's 40% maximum now. So you can see that this is an onerous tax. We'll talk more about how you can avoid it in a second. How do you report it? Well, you have to file a federal estate tax return. And traditionally, this was only done if the estate was big enough, okay? If it was close to that threshold that I mentioned. How do you plan for it? Well, it has to be paid within 9 months from the date of death. Now, sometimes you can get an extension, but you still have to pay the tax. There's ways to deal with this kind of installment payments that you can work with the federal government. We'll talk about that in a minute too. But basically, you're stuck, okay? You have to pay that tax on a very short time frame. And so if land has to be sold, it's not going to, generally speaking, command the highest price because the time frame is so compressed. So I know you all are, you're here to learn about land trust stuff, but I got to give you a little background here to understand this, because this might be a discussion you might have with your landowner. They might have heard that the law's changed on federal estate tax. They might have heard they don't have to worry about it anymore. So we're trying to give you some principles, just simple things that you can understand about this process in order to have that kind of conversation, which could be of real benefit to your landowners. So the first major principle is that between spouses, you can transfer an unlimited amount, either at death or while you're alive, and there's no tax liability, no penalty. Spouses have this right. And so people often think that, well, I don't really need to do anything to avoid this tax because there won't be any tax. Well, there won't be at the first death, okay? But unless there's a new spouse in the picture pretty quick, then what that does is it moves the assets, which were owned by husband and wife, now automatically the surviving spouse, and that's usually the wife, is going to own 100% of that asset. And so what this does is it increases the size of her estate, could push her over that threshold and create more of a federal estate tax liability at the second death. So this isn't so much a tax avoidance principle as it is a tax postponement principle. Here's a second major principle. And this is where the law has significantly changed. Every individual has this federal exemption. Sometimes it's referred to as a credit, such that you can pass, according to the new law, up to $5 million to anyone, non-spouse, right, without paying federal estate tax. This could be a transfer during life in terms of a gift, or it could be a testamentary transfer, a transfer that's made at death. So you can pass up to that amount without any tax. The Taxpayer Relief Act at the end of 2012 indexed this amount to inflation and made it permanent. So it's $5 million now going forward. It's not going to change unless Congress, does something strange again. It's not floating, it's not adjusting every year, every other year. But it is indexed to inflation. So this year in 2013, it's $5,250,000. So you can expect next year that's going to go up incrementally. So this exemption amount is personal to the individual. It applies to transfers to non-spouses, because remember, between spouses, there's the unlimited marital deduction. So if you put both married couple, both husband and wife together, they can pass a total of $10,500,000 in 2013. Again, that amount will increase slightly. So if the ranch with the easement on it is less than that value, and that's the principal asset in the estate, then it's very likely that a very simple estate plan for that couple will avoid federal estate tax, and things will just continue to roll on. There won't be any sort of liability at the second death. Now, one of the things that the 2012 Act also made permanent was the portability, it's referred to as in a code, portability of any of the decedent's unused exemption at the first death to the surviving spouse. So spouses now, so get this, it used to be use it or lose it. Husband died. If he didn't give that $5 million to the kids in a trust or something, and everything passed to the spouse under the unlimited marital deduction, that credit went unused. Okay? Now at wife's death, the second death, all she has is her credit. That was the example we used before. Now what you can do between spouses is transfer the unused exemption amount, so that now at the second death, wife has her $5.25 million and the decedent's $5.25 million. So this is something new, and this will ease a lot of the planning for many families, but there still might be important and useful reasons to use exemption planning and use trusts at the first death. So I want to talk about this portability because, again, this is something that is an important part of this conversation with landowners. The exemption portability applies between spouses only, and the last spouse controls. In other words, husband dies, and he's got an exemption amount, but wife remarries. Okay, well, the second spouse's exemption amount is what controls, not the first. She gets married 7 times, it's the 7th husband. Whatever exemption amount he has, that's what she has at her death. You can elect the full exemption amount or a partial amount, but it does require the filing of a 706, this estate tax return at the first death, in order to quantify the amount of the exemption that will be transferred to the surviving spouse. If you don't file the 706, the exemption doesn't automatically transfer. So this is going to lead to a lot more filing of 706s in the future in order to lock in this exemption amount. And there are also tax implications for using the exemption amount, which I won't go into. I'll just point that out to you. So with regards to capital gain tax and the sale of assets. Well, let's just bring this home now with an example very quickly. This is the Poor Planning Ranch, all right? So these are land-rich, cash-poor clients, landowners. They've got a very valuable piece of property. It's about 1,000 acres up on the Pedernales River. And actually, that $12 million should be $15 million in that case. But they have this ranch. It's the family ranch. It's been in their family for a long time. They got some cash that if they scraped up everything, sold stuff, they could probably come up with $1 million in liquidity. They have this exemption amount. Husband and wife have each this exemption amount. So what happens when the first spouse dies? Well, the first spouse can shield under the exemption $5.25 million. Their estate's bigger than that. The decedent's estate is bigger than that. So the estate would technically be taxable, but because everything was given to the surviving wife under the unlimited marital deduction, there's no federal estate tax. Hooray. But the poor planning folks did not file the 706 at the first death, at husband's death. And as a result of that, the husband's exemption amount goes unused. It's not portable to the survivor. So what happens at the second death then? Wife shortly joins husband in the great beyond, and kids are left to tally up the size of the estate. Well, $12 million ranch and $1 million in cash, but they can only use mom's $5.25 million to shelter from the estate tax. So that means there's a taxable estate of almost $8 million. Let's run the numbers. We're using a 40% federal estate tax on every dollar over that exemption amount of $5.25 million. What does the IRS get? $3 million. Well, how is this family going to pay for that federal estate tax when they only got $1 million at best in liquidity? If the ranch is under an easement and it provides for a subdivision, guess what's going to happen? They're going to have to exercise a subdivision right and sell off a portion of that ranch in order to pay the federal government. So you can see where this would drive the exercise of reserved rights in that scenario. Well, let's say they had good legal counsel and they used the exemption amount. Now what they're working with is husband's exemption amount. The 706 was filed at husband's death, so wife has both exemptions. So at her subsequent death, they can shelter $10.5 million. That greatly reduces the taxable estate. Now there's only $2.5 million that is subject to this 40% tax. So run the numbers. The federal estate tax drops to $1 million. They might not have to exercise that reserved right. So you can see that the use of portability under this scenario saved over $2 million in federal estate tax. And that's why this is an important consideration to know about, and to maybe as part of your overall discussion, if the landowner asks you, have you heard about this? What'll happen when I die? How will this all work out? That might be an issue that will be important for you at least to understand so that you can talk about it and spot the issue. Because about the only thing you can do in that situation is tell them you need some help. You need someone to help you plan, but there's ways around this. And this gets to the main point of this part of the thing. In Texas, I think it's Carter Smith has this great line, Texans love Texas so much they're loving it to death. And so what is happening is there's a confluence of bad tax law, especially over the last 10 or 15 years, and poor planning that's fragmenting our ecosystems. as this intergenerational transfers are made at every generation. In the next 10 to 20 years, there's going to be trillions of dollars in value changing hands. And Texas will have a big chunk of that value because land is very valuable here. And if the planning isn't done correctly under the current law, then we're going to see much more of this fragmentation. So husband and wife have 1,000 acres and they've got 4 kids. What do? Well, gee, we treat the kids equally. When I die, when wife and I die, they each get 250 acres, right? Well, you can see how it doesn't take many generations before people are living on postage stamps or there's tremendous family conflict. And this gets us to the intersection between conservation planning and estate planning. Remember, we're talking here about legacy land. If we're just talking about a bank account somewhere, it's not gonna, those are easy assets to deal with in the event of disability or death. We're talking about legacy land. Legacy land are lands that people have an emotional connection with. They love their land. That's why they've come to you to protect it. And they have a vision for that property. They want to pass it on. Usually it's to heirs. Because what they're trying to do here is not just pass an asset, they're trying to pass a set of values. If you've heard me speak in the past at this conference, this is my soapbox. I got it for the next 2 minutes. Land is different, and landowners see the land differently than any other asset that they own. There was a study done by the Heritage Institute a few years back, and they asked the baby boom generation what was the most important legacy they received from their parents. Now, these people that ran this survey had a hidden agenda. They wanted the respondents to say the money, because they had a financial plan that they were prepared then to offer, okay? So they were looking for data to support the marketing of their financial plan. They did this big survey. Baby boomers, what's the most important legacy? The money came in 7th. What came in the top 3? Well, you'd be surprised. It was the family stories, the family history. It was the example that my parents set with their charitable giving. It was their community service that they taught me. That was the most important legacy. Kind of restores your faith in humanity, doesn't it? And the land came in after those things, but above the cash. Why? Because, again, the land is connected to values. And when mom and dad are passing the ranch with a conservation easement on to the next generation, they're trying to give those children some security, but not just financial security, security in terms of values, in terms of identity, in terms of a place to come to for generations to come. And that's why land is so different in this context, and why your work, working with landowners to protect land in this way, is so important and such an important part of any estate planning that we do. There, I'll get off my soapbox now. So, last thing I want to touch on are all of these other more advanced planning strategies that can be part of a comprehensive plan that you might run into, and that could be important to you as land trusts to know about, and landowners, the few of you that are here. So I think charitable giving speaks for itself. At the end of last year, the $5 million exemption was scheduled to expire and be replaced with $1 million exemption. This scared landowners like crazy. And a lot of them entered into more sophisticated strategies as part of their wealth transfer, pushed by that deadline. So there was a lot of intergenerational transferring done in December. Probably the biggest wealth transfer in history, in American history anyway, occurred in the month of December of 2012, as families sought to shelter the ranch, shelter their assets from that $1 million exemption. So they pushed it to the next generation. Now there's all of these different ownership structures that are in place. Maybe the kids are entitled to the property, or maybe the grandkids are entitled to the property, or maybe a trust is entitled to the property. And that can create potential conflicts. If there's multiple owners, sometimes we've been asked to create user agreements. If the property is subject to an easement, those user agreements take into account the fact that the land is restricted. I want to talk about an asset replacement trust. So typically, husband and wife own the ranch, they got 4 kids. 2 of the kids love the property. They'll be happy to receive the property, but 2 of the kids live in the city. They don't really have any connection to the land. They like to go out there to hunt, but they don't want the responsibility of ownership. So what does mom and dad do? Well, in their thinking, it's you treat the kids equally. So you're each going to get a quarter of the ranch. Well, what's that going to create? A problem for those heirs. There's going to be conflict aplenty. Why? Because there's no money. There's no way to equalize the distribution of the asset. So one technique that we use is an asset replacement trust. We put a second to die life insurance policy in an irrevocable trust, so it's separated from mom and dad. It's not in their estate. It's not included in their taxable estate for federal estate tax planning purposes. At the second death, there's a payout of money. Now what is owned is the ranch and a bunch of money, okay? Now when it comes to divide things equally, a bunch of money goes to the kids that need it and want it, that live in the city, and the land goes to the heirs that want to live on the ranch. So that's a device that can be used to equalize estates in that situation. I have seen estate plans created where a portion of the residuary of the estate goes into a special trust that's only used to manage the property, to pay the property taxes, to fix the fences, to run the operation. Why? Because it's very often the case when next generation, who doesn't have maybe a big connection to the land, gets the ranch, they don't want the responsibility. And if they have to come out of pocket to pay the taxes, to fix the fences, they're going to be mad. So mom and dad say, okay, here's this a kind of endowment, similar to your stewardship endowment, that'll act as a perpetual operating fund. And this will greatly reduce conflict in the family too. 6166, installment payment. I'm going to mention that in the context of a larger strategy. So very quickly, I'll tell you the story. Elderly woman, 90 years old, no heirs, owns a couple thousand acres on the Devil's Backbone. Dies. Before her death, she told the ranch manager, I have no heirs. If you promise to never subdivide this property, I'll give it to you. He loved the ranch. He said, sure. She died. He got the ranch. Hallelujah. He's an instant millionaire. But he owes $3 million in generation skipping taxes because he was substantially younger than her. Okay? That triggered a generational skip tax. Federal government knocked on his door. There's a $3 million tax bill owing. What's he going to do? He doesn't have any liquidity. So what he works out with them is an installment payment of the federal estate tax. He says, hey, this was the principal asset in her estate. I don't have the money to pay this under the circumstances. This is an ongoing operation here. We're not generating enough income to pay you, but we're going to create this opportunity to pay you over time. Federal government says you qualify under this 6166 statute, and we're going to give you 15 years at a very low interest rate. The first 4 years are interest only. That's a great deal if you're a landowner and you're facing this liability. But still, he's over a barrel. He's got 15 years to come up with $3 million. He's scratching his head. He promised her he'd never subdivide it. It's not under easement. He could easily sell off portions of it and pay this, and that's what his first advisors told him to do. Just sell it off. Just sell it off and pay the tax and be done with it. And forget about your promise to the person that entrusted this land to you. So what we're involved in now is creating a mitigation bank on this property for endangered species. When we do that, it'll generate between $3 to $5 million in income over time. He has no hurry for the money. So now there's a mechanism not only to pay the federal estate tax over time, but to generate a pile of money to operate the ranch. That's called a home run in the estate planning world. And that's the kind of planning that you have to be knowledgeable about in your discussions with landowners whenever this topic comes up or whenever you choose to broach this topic. So there are many choices to a landowner if they want to preserve, protect, conserve their property. And when we're sitting down with someone that has land, has real estate that is legacy land, they have a vision for, there are many different choices. So we run them through a process to analyze, really, what are your goals? Here are different techniques to use this. You've all heard of deed restrictions. Those aren't very good. And these are the types of clients that are good clients for using a conservation easement as part of an overall estate plan.